This is Eye on Bankruptcy, brought to you by the American Bankruptcy Institute.
Welcome to the February episode of Eye on Bankruptcy, a monthly discussion and analysis of recent cases and developments in the bankruptcy world, produced by the American Bankruptcy Institute. This program will give you 1 hour of CLE credit in states where it is pre-approved. My name is Charles Tabb. I am the Mildred Van Voorhis Jones Chair in Law at the University of Illinois College of Law. This semester, I'm the Jack N. Pritzker Distinguished Visiting Professor of Law at Northwestern University School of Law. I'm also of counsel with the law firm of Foley & Lardner, LLP in Chicago. I'm your host for Eye on Bankruptcy. We're very fortunate today to have two distinguished guests, the Honorable Michael B. Kaplan and Brian Lohan. Judge Michael Kaplan presides in the District of New Jersey. He was appointed in 2006. Prior to taking the bench, Judge Kaplan served as a standing Chapter 13 trustee as well as an appointed trustee in cases under Chapter 7, 11, and 12. Judge Kaplan received his A.B. degree from Georgetown University and a J.D. from Fordham University School of Law. Over the past 30 years, Judge Kaplan has spoken to numerous bar associations and business organizations, and he teaches as an adjunct professor at Rutgers University School of Law. Judge Kaplan is a prolific author on bankruptcy issues. He's co-author of West Consumer Bankruptcy Manual, also serves on the editorial board for the American Bankruptcy Law Journal. And he's been a past guest on Eye on Bankruptcy. Welcome back. Our second distinguished guest is Brian Lohan. Brian is a partner in the Bankruptcy Restructuring Group at Arnold & Porter, resident in its Chicago office, but also spends significant time in the firm's New York office. Brian's practice encompasses all aspects of corporate reorganizations, bankruptcy, and insolvency. He has experience representing Chapter 11 debtors, note holders, bondholders, senior lenders, and other creditor constituencies. In 2017, Mr. Lohan was selected to the American Bankruptcy Institute's inaugural 40 Under 40 list, which recognizes the leading bankruptcy, insolvency, and restructuring professionals from around the world. Brian has been an adjunct professor as well at the John Marshall Law School in Chicago, teaching bankruptcy law. He earned his J.D. From Northwestern and his bachelor's from DePaul. Today, we will be discussing 6 issues and cases, which we have taken from Rochelle's Daily Wire, available on www.abi.org. If you're keeping track, our discussion today will cover the following topics and cases from the Rochelle Daily Wire. First, ubiquitous, it never goes away. Must new value remain unpaid, in quotes, to satisfy the preference defense under 547C4, a bankruptcy case out of the Northern District of Illinois called Calumet Photographic. Next, the ongoing war between J. Alex and McKenzie which deals in this particular with the requisites for appellate standing, a cert petition to the Supreme Court in the Marbo Value Partners situation. Thirdly, is paying tuition for adult children a fraudulent transfer if the parents are insolvent? Similar to an issue we talked about a couple months ago. This is the Sturman and Pincus case out of the bankruptcy court in New York. Fourth, are direct mortgage payments, quote, provided for, close quote, in a Chapter 13 plan? We have a circuit case, the Dukes case out of the 11th Circuit. Next, under Chapter 15, where is the, quote, commi, or the establishment for an individual? This is the Pirogova case, bankruptcy case out of New York. And finally, a very interesting case where the securities safe harbor 546E was applied extraterritorially in Madoff clawback actions. This is one of the Fairfield Sentry bankruptcy cases out of the Southern District of New York. So, let's start then with the first topic, which inexplicably won't go away. This is something from my various early years in teaching that seen courts were getting wrong. The question is, it's one of the important preference defenses, must new value, quote, remain unpaid in order to qualify for the new value defense? Now, the answer surely is It depends, and that's assuming a court can read English, but somehow against all reason and grammar, my home circuit, the Seventh Circuit, has steadfastly maintained for over 3 decades that new value must remain unpaid no matter what. We may have a vehicle that could potentially lead to a Supreme Court resolution of this issue. We have the case we're going to talk about today, the Calumet photographic case, which I can describe as only grudgingly decided by the Honorable LaShonda Hunt, the bankruptcy court for the Northern District of Illinois in January, who felt that had no choice but to follow the precedent of her misguided circuit. But virtually all the other courts the circuits that have looked at this have held that new value does not necessarily need to be unpaid. It might help here for us to actually look at the statute that Congress wrote, sometimes thought to be an appropriate course of action. And if we do, indeed, there are some situations where the creditor would lose the new value defense if it gets paid. But the point is, the basis is much more nuanced. So to start, we're going to take a look at the statute. Sometimes can be helpful. It says in 547C4, the creditor has a defense, quote, to the extent that such creditor gave new value to or for the benefit of the debtor, ... And this is the key part, on account of which new value the debtor did not make an otherwise unavoidable transfer to or for the benefit of such creditor. Okay, so Judge Kaplan, let's consider what the statute says. It appears there are some cases where the creditor loses the defense if it gets paid, but not necessarily. There may be other cases where they would still have the defense. I know this is something you've written about. So, Judge, what is the key issue that determines whether the new value defense is or is not available to the creditor when the debtor did, quote, pay for the new value?
All right. Well, we're going to start where we should, with the statute and the language of the
Never
statute
hurts.
itself. Never hurts. The language here is hard. It is replete with double negatives. The key issue is whether the last payment is an otherwise unavoidable transfer. Not just whether there was a payment, but whether the last payment is an otherwise unavoidable transfer. And to break that down into more understandable terms, we look at, I actually can phrase it, did the creditor get paid for the extension of new value by a payment that can be clawed back? It's as simple as that.
Do they get to keep it or not?
Right.
And that's what the statute says. It says, were they paid by an otherwise unavoidable transfer? Well, just to try and put some meat on the bones here and have some context, let's try and work through a simple example. And so listeners, so you can try and keep track of this. Let's just assume, simple case, debtor owes $10,000 to the creditor at the beginning of the preference period. Then, during the 90-day preference period, we have the following transfers. Firstly, we'll say March 1st, the debtor pays $10,000, the amount they owed. But a month later, creditor makes a credit shipment of $8,000. 2 weeks after that, debtor makes another payment of $7,000. So we had initially a $10,000 debt. We had a $10,000 payment by the debtor to the creditor, followed by a new credit shipment of $8,000, followed by a payment by the debtor again of $7,000. So, Judge, to figure out the application of C4 on these facts, what we need to know is what the status is of that final payment, the April 15th payment of $7,000, correct?
Correct.
And
Good.
so assume first, so walk us through this. If that payment, the final payment itself, is avoidable as a preference, then what?
Well, then the entire $8,000 in new value given on April 1 could be used as a credit under 547C4 as to the preferential payment that was received.
And tell us why.
It's just an offset that you would look to see, could that, did the debtor make an otherwise unavoidable transfer? Could it be clawed back? And then you would say, okay, if it could be clawed back, then certainly
which on
the
this
creditor should.
hypothetical it is.
Right. If it's clawed back, then the creditor should get the benefit of it.
And so if we do that, then on our facts, the total preference would just be $9,000. That is, the initial transfer of $10,000, $2,000 of that is going to be because we have an $8,000 new value defense, plus you have the $7,000 you said by definition is going to be clawed back. Here's the scary part and where the Seventh Circuit approach leads to problems. What is the consequence if a court mistakenly requires that $8,000 in new value to, quote, remain unpaid, no matter what, without considering the voidability of the later payment? What happens then?
Well, then the creditor is certainly open up to greater exposure.
Explain.
Because if you're just looking as far as the payment, then yes, then the creditor is only going to get a $1,000 benefit from that initial extension of new value, and is still exposed to that the $7,000 new value additional payment made right before the bankruptcy.
So effectively, what would then be happening under this remains unpaid no matter what, without reference to the voidability of the final transfer itself, the paid transfer, effectively on these facts, that $7,000 payment is used against the creditor twice.
Right.
How so?
It's not only applied against the initial new value given. It's applied.
So it
again,
reduces that credit.
It reduces that credit to $1,000, or whatever the amount is. It then opens the door to greater exposure at the end, with the creditor having to come up with new affirmative defenses to try to offset it.
And so it's just patently unfair to the creditor.
It is.
But now, if conversely we say the final payment, the paid part, that $7,000 hypothetical, if it were not avoidable, so I don't know, I mean, it was ordinary course defense, whatever. For whatever reason we decide that was not avoidable, then how do things play out?
Then, if it's not avoidable, the creditor doesn't get the benefit of that new value defense, but by application of the statute, not by a strained reading of the statute. Now, I'm glad you had referenced and commented about the strange approach taken by the Seventh Circuit. I was very grateful that I had looked back in opinions that I had written. I have a case, a published opinion, Dots, in which I applied the growing majority trend. Because
the one that can actually read the
very
statute?
awkward here today, having to defend what I had written if it was inconsistent. But yeah, it's the irony here, though, is if you adopt the majority trend, you are asking that creditor at some point to argue against self-interest.
Yeah.
It may be the same result, but at the end, they have to argue that, nope, that last payment that I received was avoidable, without a doubt. My affirmative defenses do not stand up, because having it avoidable
but then they at least get to credit it as part of the new value.
Right.
And I mean, it's interesting that the situation where the final payment is itself, well, is probably what the Seventh Circuit was thinking of, and it's just the unfortunate situation where they just kind of paraphrased what, as you said, we have to ask, can the final payment itself be clawed back or not? Now, even moving aside from the statutory language, which, as we're saying, really is pretty clear here, what is the policy play here? How does this work out? What's C4 in the statute for? How does it work out in this situation and so forth?
Well, let me just preface it. We shouldn't have to look to policy. We should be able to rely on the plain language. That's Scalia-esque approach.
Yes.
But if we're forced to and constrained to, and really we should, if you look at the underlying purpose of the new value defense, it's to encourage creditors to continue to advance credit to the debtor during a period of questionable solvency. And if they have to worry about whether the new value they're extending is going to be subject, that any defense is going to be subject to the happenstance of getting another payment, it undercuts the viability.
It really does, yeah. And which is why Congress wrote the statute the way they did, as you carefully explained, with the otherwise unavoidable new transfer, because then they're sufficiently incentivized. they do, as you say, they have to give back the payment once, but not twice, and that's the approach. So let's get out our crystal balls. Let's say hypothetically this goes to the Seventh Circuit, and they continue to say we're right and everybody else is wrong. We have a circuit split. Let's say it goes to the Supreme Court. Judge, how do you think the court would decide this question?
I think.
And then Brian, I'm going to ask you the same thing.
Every Supreme Court decision that I've read come down in the last, 10 years or so has focused on plain language. And I have to believe they don't go beyond what you and I think any rational observer would view as clear dictates of identify whether or not the last transfer was avoidable.
So the majority approach is where they're going to go.
And they'll buttress it just to make everybody comfortable with the policy aspects.
Just to show Congress didn't make a mistake, it
Absolutely.
makes sense. Your thoughts, Brian?
I agree. I think the statute's pretty clear, and I think the policy is pretty sound.
Yeah, and it really is. I mean, one reason we talked about this is just to remind our readers that there is a minority view that is really hard to understand in the face of the statute. Our second topic is one, this has come up before on this program, but we've been having a fascinating, if you like such things, war arising out of the Alpha Natural Resource case and elsewhere between J. Alex, this time in incarnation as Marbo Value Partners, and the McKinsey consulting firm, relating really to McKinsey's disclosures in the Alpha Natural Resources case and in other cases as well. Interestingly, the current ballot we're going to talk about today could have a major impact on the requisites for appellate standing. In the district court and in the Fourth Circuit, Marbo's appeals of the bankruptcy judge's decisions about McKinsey's disclosures were dismissed for lack of standing. The ground was that they lacked pecuniary interest, therefore could not meet the person's aggrieved test. Well, to challenge this, they went and hired some pretty heavyweight folks. They got Larry Tribe to play the con law angle, and Susan Freeman, a very famous bankruptcy professional, who have petitioned for certiorari with the Supreme Court, asking the court to recognize an exception for appellate standing even where the appellant lacks pecuniary interest, in order to vindicate the public interest, and especially when the integrity of the judicial system is at stake. So, Brian, let's have you get us started here. First, I know a lot of people know something about this, but can you give us a bit of background, give our listeners a bit of background about exactly what this fight was about over McKinsey's disclosures in the Alpha case and so forth, and sort of, what specifically the bankruptcy judge ruled, and then sort of where it went from there?
Sure. Well, McKinsey was the turnaround advisor to Alpha Natural Resources. As in every case, the debtor was required to file a retention application to retain McKinsey. And in connection with the retention application, McKinsey filed a Rule 2014 disclosure, and it indicated that it had connections with approximately 138 parties in the case, but they only included general descriptions. The court approved the McKinsey retention without any opposition, and later Marbo challenged the adequacy of disclosures under Bankruptcy Rule 2014. The bankruptcy court did order McKinsey to provide additional disclosure, but the additional disclosure, which included some client names of McKinsey, was only required to be filed in camera, and the public did not have access, nor did Marbo, to the additional disclosures. After reviewing the additional disclosures, the court was satisfied with the information provided by McKinsey and McKinsey's disinterestedness. Marbo then appealed the bankruptcy court's orders limiting the disclosure obligations and directing.
So they appealed to the district court.
They did.
And the district court, and in the Fourth Circuit, summarily affirmed the district court. What exactly was their ruling? The basis of their ruling?
Well, the district court dismissed the appeal on the ground that Marbo lacked a pecuniary interest in the outcome of the appeal, and therefore could not meet the person's aggrieved test for prudential standing in the bankruptcy context.
Gotcha. And so in their the Fourth Circuit said, yes, that's right. So what exactly is the test in the petition for certiorari that Marbo is asserting should be applied in this case? And how does it differ from the test that was applied below?
Well, the person's aggrieved prudential standing test is stricter or more restrictive than the Article 3 standing requirements. It requires an appellant in a bankruptcy case to demonstrate that it is directly and adversely affected pecuniarily by the bankruptcy court order that it's appealing. Marlboro failed the test because Marlboro's economic interest became fixed when the plan was confirmed. So even if Marlboro was ultimately successful,
They don't get more money.
they don't get more money. In the cert petition, what Marlboro wants is they want the court to require or recognize an exception to the person's aggrieved test that permits an appellate standing for appellants lacking a pecuniary interest in order to vindicate the public interest.
Okay. And so a couple of different plays they made there. They talked about Supreme Court precedent. They talked about other circuits, talked about an important federal interest. What's the Supreme Court precedent that in their cert petition they said was contrary to the sort of like stringent application of the pecuniary interest person's aggrieved test?
So what Marlboro is referring to when it talks about the Supreme Court precedent, it's the Supreme Court questioning the continuing vitality of doctrines that allow courts to decline to address matters on prudential grounds rather than statutory or contractual or constitutional grounds.
Gotcha. And so the other circuits, tell us about the exception that they've developed. I mean, Marlboro asserts in their cert petition that several other circuits do recognize an exception. Tell us about that exception and then how it would be applied in this case.
Sure. So according to Marlboro, the 2nd, 3rd, 6th, and 11th circuits hold that even absent a pecuniary interest, a public interest may also give a sufficient stake in the outcome of a bankruptcy case to confer appellate standing, especially when the integrity of the court is called into question. Specifically, Marlboro cites a Third Circuit case where, and ironically or not ironically, it also involves retention of professional, where the objectors in that case were permitted appellate standing because despite the fact that they lacked a direct pecuniary harm, because the appeal order would affect the fairness of the entire bankruptcy proceeding.
And this leads to sort of their point about an important question of federal law. And what is that question of federal law, and why is this relevant to the bankruptcy system? I mean, why should our viewers care about this? What's going on here?
Well, it really boils down to the fiduciary obligations of bankruptcy professionals, the prohibition on holding or representing adverse interest, requirements of disinterestedness, and the mandated disclosure obligations enabling courts and parties to evaluate the professional as disinterested.
And so what would be the impact? I mean, so let's say, let's play it a couple ways. Let's say the court does grant cert, and let's say they agree with Marlboro. How will that impact the bankruptcy system? What sort of practical implications do you see? I mean, are there some types of orders or things that would become appealable? Are there bad things that would happen? I mean, how would the leverage change? What would happen here?
So the easy answer to that question is the universe of parties with appellate standing on certain issues will expand. Mm-hmm. But I think how the court reaches its conclusion will be more responsive to your question.
Explain.
Of particular note, it will impact or potential impact on other doctrines that limit appellate review, such as equitable mootness. In terms of your question about otherwise unappealable orders or other, would it expand? You know, obviously retention orders that are subject of this case,
yes.
Potentially fee orders. There was some discussion in a footnote in the cert petition talking about unsuccessful bidders being able to challenge unfair auction process. Of course, 107 sealing or unsealing decisions and Rule 2019 disclosures.
Yeah, so a lot. Judge, your thoughts? You see lots of stuff come before you in court. Is this a good play? Do you like the idea of what Marbo's pitching for, or do you think we're better off staying with the pecuniary interest, persons aggrieved, prudential test?
Well, let me start with, I'm always a little leery of decisions which undercut the viability of prudential limitations on access to the courts.
Okay.
Brian mentioned equitable mootness. You have rightness. You have abstention doctrines. They serve a valid purpose to foster judicial economy, comity with the states, fairness to the litigants, and very often just to prevent a hurdle or a bar towards using the courts as a manipulation in order to effectuate some policy rather than to redress grievances. Now, having said that, I'm not in favor of any single strict pecuniary approach because I think that's short-sighted.
Okay.
I think you have to look on it on a case-by-case basis. There are situations where there can be significant harm to parties in interest, but they can't dress them up as financial harm. As an illustration, we've had some contested 363 sales of hospitals and the impact on communities. And you have a community that's without emergency services. Not a financial harm, but those concerns have to have access, those seeking to address those concerns have to have access to the courts. But I think there has to be some overview, some limitation.
And a final question on this: do you think? And I think a worry, and one reason, of course, one of the reasons these prudential type tests develop. Do you worry about a floodgates? I mean, if we say we'll relax the pecuniary interest part, is it then like everybody and their brother can come in and just start appealing everything, or do you think that's manageable?
I hope it's manageable. As I said, I think you do need to address it on a case-by-case basis. It puts pressure on the trial courts.
It does.
Whether it be evidence or parties seeking to argue, the tendency is to let it all in. I know that's the approach I take. We'll sort it out afterwards. The district court can review it. We'll let the parties be heard. But there is an important bankruptcy policy of expediting the administration of a bankruptcy case.
Of course.
And we lose that ability when we sometimes have to address issues and concerns that are not the immediate needs of the debtor and the creditors.
And so perhaps, I mean, if we just think about it, the courts, and they probably would be able to, I mean, the thought of specter of like every losing bidder at a sale being able to complain about it, it's like, really? But like, okay, this was the only hospital in a 50-mile region. Now we're feeling like maybe we should be able to talk about that going up through the courts. Well, speaking of things going up, in the December episode of On Bankruptcy, we talked about an issue which I think most parents in colleges and universities are terrified of. It's sort of a current hot issue in the same way the transfers to charities was back 25 years ago, which is it a constructively fraudulent transfer for an insolvent parent to pay college tuition for an adult child? We had speculated about this in December, and we now have an actual case. The Sturman and Pincus case, Judge Martin Glenn of the Bankruptcy Court, Southern District of New York, held in December on summary judgment that it was constructive fraud, this is a matter of law, for an insolvent parent to pay tuition for an adult child. Reason being, as a matter of constructive fraud, if you assume insolvency, which we'll say was not on the table at this hearing, saying there's no reasonably equivalent value under 548 of the code, and under the New York fraudulent transfer law, the same idea, no fair consideration. Judge did find that there was reasonably equivalent value or fair consideration for the parent to pay tuition for a minor child. So, the specific issue the court was deciding on summary judgment was this reasonably equivalent value issue, which the judge broke down into two categories. Firstly, asking, did the debtors receive reasonably equivalent value for their daughter's college education and so forth because being educated would enhance their self-sufficiency, the daughters? Secondly, does it matter whether the daughters were above or below the age of majority at the time the transfers were made? Just very briefly in the case, the debtors had made a number of payments on behalf of their daughters, Alexandra and Samantha, to Oberlin College, not an inexpensive place, before and after they turned 21, and made other transfers to Alexandra after graduating from college. So, Brian, there were 3 categories then that Judge Glenn sort of put these in, and then he went through them one at a time and said yay or nay on reasonably equivalent value.
The 3 categories that he created in this decision were transfers made for education-related expenses that benefited both daughters after they reached the age of majority.
Above the age of majority, okay.
Above the age.
Okay.
Transfers made for education-related expenses for the benefit of Samantha, the one daughter, while she was a minor.
Okay.
And then transfers made to Alexandra after she graduated from college.
Okay. So those are the categories. Now, let's start with one of the more challenging ones, which is the education-related transfers, not just the here you go, Alexandra, but just education-related after the daughters reached the age of majority. Specifically, what was the argument the daughters made that, of course, Mommy and Daddy got reasonably equivalent value or fair consideration?
So daughters argued that their parents received reasonably equivalent value because the transfers made after they were adults increased the likelihood they would be self-sufficient.
And that was value to the parents. Why? Why is that valuable to the parents?
You want your children to grow up, become financially independent,
Get out of the
off
house.
Not live in your
payroll.
basement.
Right.
Yes, exactly right. And now some courts have accepted this argument.
Yes,
Yeah. Did Judge Glenn accept this argument?
he did not.
He did not. Tell me why not. Why no value there?
He held that there was no value, and in doing so, he noted that he was constrained by the bankruptcy code and the New York debtor-creditor laws, and what those statutes define the terms value and fair consideration, and they require either a transfer of property or the satisfaction of an antecedent debt in return for an insolvent debtor's payment. And in his view, the debtors received neither.
Okay. Now, to contrast that, let's compare. You talked about the conveyances made on behalf of daughter Samantha while she was still a minor. What did Judge Glenn hold there, and what was the basis of that holding?
He found that there was reasonably equivalent value. And the basis was, and the main difference between those transfers and the transfers while after they reached the age of majority was that there was a legal obligation for a parent to provide education to a minor child. And by paying the education-related expenses, they actually satisfied their legal obligation.
So there was a discharge of a legal obligation they otherwise had. Now, one thing that was raised wasn't really, well, the judge talked about it some, but the trustee complained about this, which is Oberlin's really expensive. I mean, you could send them to SUNY, go to State U. Do you have to go to one of the more expensive private colleges in the world? I mean, is that necessary? Is there reasonably equivalent value there? How did the judge deal with that argument?
So he said it was irrelevant, and he cited to a decision by Judge Craig, which also found it irrelevant to determination of whether the debtors could have spent less on their child's education. And she also noted the trustee is not granted a veto right over the debtor's pre-petition expenses.
That's a dangerous argument, too. Talk about slippery slope, where all of a sudden we start weighing the reputation and the rankings. Clearly, there's reasonable equivalent value if you go to Georgetown, but not necessarily if you graduate Syracuse.
And let it be noted
let's say.
that Sam Giordano did let Judge Kaplan have a Georgetown mug with him.
Just to bring up that point, but
Yes.
that's a direction I don't think any court wants to start
So you're
going.
saying going to Georgetown would clearly be a lack of reasonably equivalent value, or the opposite? No.
It's beyond even question.
Yes. But, well, let me ask you this. Would it be possible, could you imagine this could come up in a scenario where it would be intentional fraud to send your minor child to the most expensive school you can find anywhere?
Well, I'm sure you can think of a scenario.
What would be
or
the
two.
reason?
If you have a parent that was insolvent but had liquidity, and said, I'd rather my liquid, assets go to my daughter's education, and I don't care about my creditors. You can see a situation.
Now, there's another whole aspect of this, which in December, actually, we talked about a lot, given the structure of the cases we're dealing with there, which is the issue that comes up, of course, under 550 with the difference between whether the target is the initial or not the initial, a subsequent transferee. So why does this matter, Brian? What's the point of the initial subsequent split, and why would a college rather not be initial?
Well, the reason it matters is because an initial transferee would have effectively automatic liability, whereas a subsequent transferee would be able to avail themselves of a good faith defense under 550.
And what would they be able to argue? What would they be able to argue if they were subsequent transferee then?
They took in good faith.
And for value, right?
For value,
They provide
right.
the education, yeah. Whereas, as we discussed in December episode, if your initial transferee, that's off the table. Now, does this suggest ideas? We talked about this a little at that episode, but how, do you have any recommendations for universities on how they structure things regarding that? Because it's so much better to be subsequent than initial.
Yeah, and I think in order to answer that, we have to consider what the Eastern District of New York has looked at a few months ago, and I think the answer to that is it depends. But I think what helps is if the student child has a separate bank account, because if the funds from the parent are going into an account, whether it be a student account at a university or to the university directly, this student would not have dominion of control over those assets, and therefore the question would be who had dominion and control over that money before it hit the university. And if it's the student, the university would be a subsequent transferee.
It will be interesting to see in the wake of this and similar decisions. I said this is an issue that's sort of a hot thing now for trustees to be looking at, whether universities do start restructuring how they provide for this. Well, speaking of structuring how things are set up, our next case is a very intriguing and recurring Chapter 13 question. The question is, it's dealt with in the Dukes case in the 11th Circuit, whether mortgage payments that are made directly from the Chapter 13 debtor or the mortgagee are those, quote, provided for in the Chapter 13 plan. We're very fortunate, Judge Kaplan, as a former Chapter 13 standing trustee. This is right up your alley. The 11th Circuit said no, not provided for by the plan. Can you give our listeners a little feel for the basic facts, the context of what was going on in the Dukes case? What did the plan say? What was provided for? What did Mildred pay? That kind of stuff.
Sure. The long and short of it is, in Dukes, the debtor's plan said basically nothing with respect to her mortgages. She had two mortgages, a first and second, with the credit union. And basically, the plan simply referred to the mortgages and indicated that the debtor would be paying them those mortgages outside the plan, directly to the credit union. The debtor addressed her other obligations under the plan. And all was well and good. The plan did not set forth any repayment terms, did not provide for a cure. It wasn't a cure and maintain plan. It didn't otherwise mention it.
And I'm paying it.
It depends. In that district, the debtors are permitted to make direct payments, not through the trustee, but through
They can just
on
pay
their
directly
own.
to the mortgagee.
And all was well and good. The debtor obtained her discharge. She made her payments over the life of the plan in 2012, except she did miss several mortgage payments. The trustee would have no way at that point of knowing about that,
Right.
Nor did the trustee really have a care or concern,
Right.
because her payments under the plan were made. We'll talk about under the plan.
Yes.
But she was delinquent in payments directly to the credit union, and she had stopped paying the credit union. The properties went into foreclosure. The second mortgage was foreclosed on. And in 2013, the credit union not only foreclosed and obtained a judgment in foreclosure, the in rem action, but they also sought to pursue her on the underlying deficiency.
Of course.
The in personam liability.
So what does she want to do then?
Well, then,
What's her play?
well, she was hopefully trying to avoid it until the credit union actually moved to reopen the bankruptcy, commenced the adversary proceeding to get a declaration that her personal liability remained, that the mortgage obligation, that second mortgage obligation, wasn't actually addressed under the plan, was not a debt provided for by the plan. Both sides filed cross-summary judgment motions, and ultimately the bankruptcy court ruled that the mortgages had not been discharged because they were unaffected by the plan. The debtor tried to argue, doesn't matter. I referred to the mortgages. I said that they were going to be directly paid. That's enough. I should get a discharge.
Just make sure I understand. So she basically wanted to argue that the reason it mattered for the debtor whether the direct mortgage payments were, quote, provided for by the plan had to do with discharging the underlying personal liability to the mortgage company.
Right, that in personam, their liability. There was no question that...
Because she had gotten her general discharge.
Exactly. The in rem liability was addressed through the foreclosure.
It is what it is, yeah. And so so she needed to argue, just so we're clear, that they were provided for by the plan, because if that's the case, then that is subsumed as part of the general discharge.
Right. 1328A provides that all debts provided for by the plan are discharged. And so she argued that the direct payments were, in fact, provided for by the plan and that she should benefit from the discharge.
Okay. So the 11th Circuit considered thoughtfully her plea for mercy and held what?
The 11th Circuit followed the path taken by the bankruptcy court and the district court and said no. The plan must do more than simply mention the mortgages. The plan's terms must in some way affect or govern or provide for repayment in order to be considered as being provided for by the plan.
She's just saying, by the way, I've got a mortgage, guys. That's not enough. You have to do something vis-a-vis the mortgage in the plan.
Right. The 11th Circuit was able to look to language that the Supreme Court had used in a different context.
They referred to the Rake v. Wade case. Talk about what they were getting at with that reference.
Well, Rake v. Wade, which is the famous interest-on-interest case, and it addressed whether 1325A5, which requires that secured creditors have received the present value for all secured claims that are provided for by the plan. It uses that language. Whether or not in Rake v. Wade, cure and maintain plans were those that were provided for by the plan. A little different issue. Yeah. But it did serve as a vehicle for the Supreme Court to address what is it meant for when you say provided for by the plan. Mm-hmm. And the Supreme Court basically said, no, you have to make a provision for the mortgage. You have to stipulate to it. They used the word reference, but and the debtor seized on it, but for the most part, the Supreme Court said, no. You have to do something more than simply mention it.
And what about the adequate protection payments? It talks about providing for adequate protection payments. The court said that's not enough either. Why not?
Right. The debtor tried to argue it, but my plan provided for adequate protection. Therefore, I'm addressing the mortgage. And the 11th Circuit said no. First of all, adequate protection payments are simply a method to ensure that the secured creditor's interest in the collateral is preserved, preserving the value. It doesn't address payment of the mortgage at all. You have to make adequate protection payments whether or not you're dealing with a mortgage under the plan.
Now, the 11th Circuit in Dukes had an alternative holding. What was that?
The 11th Circuit said, okay, even if we were to accept the debtor's argument that provided for included the credit union claims, there still could not be a discharge of the in personam liability, that deficiency, because that would violate, that would modify the rights of a secured creditor, which would be in violation of Section 1322B2, which you can't do. And the Supreme Court has previously said those rights include the ability to pursue a deficiency judgment. So that would violate 1322. And then why would you pursue as part of your plan a provision that would be contrary to the law? It doesn't make sense.
Exactly. Thank you very much, Judge. Our next case is a Chapter 15 case, which raises the question of what's required for an individual debtor to trigger recognition of a main or a non-main proceeding. Natalia Peragova, decided by Judge Shelley Chapman in New York. Under Chapter 15, of course, to recognize a foreign main proceeding has to be at the center of main interest, the debtor's coming. To recognize a foreign non-main has to be where the debtor has an establishment. The debtor in question, Natalia Peragova, very fascinating character. There were claims of fraud against her in multiple countries.
It was nice to hear a Russian fraud case involving manipulation and criminal conduct that didn't involve Mueller, subpoenas, Trump, or any of it.
We don't know that. It's the investigation is not finished. You never know. I'm just kidding. But anyway, she had been in the U.S. since 2008. She had done a bunch of fraud and so on and so forth, allegedly, in these foreign countries, every country she'd been in, apparently. 2015, one of her major creditors filed an application for personal bankruptcy in Russia. Yuri Rozhkov, I have no basis of knowing I said that correctly, was appointed trustee, petitions in Chapter 15 in New York, seeking a recognition, either foreign main or non-main. So we have the basic point where the individual debtor is a foreign citizen based on her financial and business activities in that foreign country, leads to a bankruptcy proceeding in that country, but before that proceeding commences and before the Chapter 15 petition is brought, she is moved permanently to the U.S. Very similar Fifth Circuit case, if you're interested, back in 2010, the Lavi v. Ron, where Israeli citizen did all sorts of nefarious financial things in Israel, but then decamped to Texas and became a Texan, and the Fifth Circuit said he's a Texan now, not an Israeli. Judge Kaplan.
Yes.
Important preliminary point, very critical. What's the time point, the critical point in time as of which we decide combing or establishment?
There aren't that many cases on this topic,
Yeah.
and there are two potential time periods. The first period being when the foreign proceeding is initiated,
Yep.
and the second period being when the Chapter 15 is filed. In this case, the court followed the approach taken in 2013 by the Second Circuit in Fairfield Century, which looked to the time of the Chapter 15. That's also consistent with the Rand case you mentioned.
Yes.
They both looked to the time of the Chapter 15 filing. It differed from, I think, the Southern District case in Kemsley, which was an individual case that said, no, go back, look to see where they were and what they were doing when the foreign proceeding was
When the
filed.
foreign proceeding, yeah. Now, there is, even if we go a Chapter 15 petition date, though, courts have said there's an exception to that. And what would you have to show, and why is there that exception? And what would be sort of a scenario where that might be relevant?
Well, the courts have said, okay, we can look back beyond the filing of the 15 if the debtor has engaged in certain manipulation, has undertaken what's been called bankruptcy tourism, shopping around for a bankruptcy locale with the broadest discharge terms or other benefits, and if there's been some manipulation of Comey, that they view it as bad faith.
Yeah, which we did not. There's no real allegation in this case that was going on. Now, okay, so for an individual, our key play is going to be the presumption of Comey for an individual, which is habitual residence. That's sort of, it says that's what we presume. Russian foreign representative argued that Natalia's habitual residence was in Russia. Why?
Well, the foreign representative cited to numerous factors regarding her connection, her nexus to Moscow. They included that she owned property in Moscow, that she had been evicted from her home in New York, that her Florida property was in foreclosure, The foreign rep also pointed to the fact that she owned a Mercedes-Benz that was still registered in Moscow, that she was receiving utility bills, that she belonged to a yacht club. Who knew there were yachts in Moscow where there was a yacht club?
I did not know that.
But those were the connections that the foreign representative argued.
And they pointed to similar ones with regard to establishment as well. So, and the court did not reject the idea that even if a debtor, an individual, had been living in the U.S. permanent status for 10 years, that it was impossible for a comey or establishment to be somewhere else. What might suffice, do you think? I mean, even if she had moved there, and that, I guess, could tell people what they need to be careful to do and not do if they don't want to be dragged back to the Russian proceeding.
Well, look to form other connections.
Okay.
Whether it be a community organization, joining a temple or a church. Where are the kids being schooled? If you have relatives in one place, what is your history of seeing them?
Court actually talked a lot about
right.
that here.
They pointed,
hey, she still has family in Russia. Like,
well,
yeah.
the foreign representative went to the apartment in Moscow but couldn't tell when the debtor was there last. You have to be able to prove, if you look at utility bills, who's using the utilities?
So
When
you're
was
saying
the
it would be
debtor there?
even if you've moved to the U.S., if you just can't get Mother Russia out of your blood and you're tempted to go back and visit on a regular basis and see the family, and if you keep an apartment there and drive your Mercedes, that's bad.
If you keep bank accounts there, if you keep a storage facility there, if you do any type of work there, that's all going to work against you. It's really very fact specific. But the problem in this case was the foreign rep just didn't go to the next step, didn't have the proofs.
Yeah, and really the same kind of issues came up with regard to the establishment. The test for establishment, of course, is what?
Again, for an individual case, it's been defined as does the debtor have a second residence there, or are they transacting business there? And so you again look, yes, there's a residence, but when was she there?
Yeah.
Who was there? Is she really doing business there? Is there a job? Are there other indicia of commerce?
Yeah, and this, I mean, one can spin out many scenarios. It's a very interesting problem, the mobility, like when you can move. I mean, in picking between the date of the commencement of the foreign proceedings versus the date of the Chapter 15, if we freely allow debtors to leave the other country and then like preclude them being able to get recognition in the U.S., but take assets here, it could be a problem. Okay, time for the final case, which is quite a case, and involves yet again, probably how many times on Eye on Bankruptcy have we been able to talk about our friend Bernie Madoff, which as I was preparing for this, I realized the clawback litigation in that case is closing in on a decade, which is truly hard to believe. And relevant to what we're going to be talking about today, much of that litigation is centered abroad. Bernie was happy to take money from anybody around the world. A lot of the foreign litigation has come up through these what are so-called feeder funds. They would take money from investors and reinvest with Madoff. And indeed, there were even funds of funds where they would invest with other funds who were invested with Bernie. What, of course, then happened, especially with these feeder funds, once Madoff collapsed, they collapsed. They were all like completely insolvent, essentially. And in their home country, they would have bankruptcy proceedings instituted. Some of the largest and best known of these involve the Fairfield Century funds, which have been proceedings in the BVI, the British Virgin Islands. Now, no question, BVI was the comey for those funds. Chapter 15 proceedings brought in the U.S., BVI proceedings clearly recognized without dispute as foreign main proceedings. What happened, which is going to be relevant to what we're talking about, is the liquidators of those funds, the BVI liquidators, have instituted clawback actions both in the BVI and in the U.S. on a whole slew of legal theories, of course trying to claw back redemptions that were made by investors in the years before Madoff's fraud was exposed. Specific for today, there are adversary proceedings, 305 adversaries the BVI liquidators had brought in the U.S. court, and the specific defense raised was the contention of the defendants, Brian, that whatever the merits on the substance of the clawback claims under BVI law, and the Judge Bernstein's opinion spends 50 pages talking about all of that, we have a safe harbor. 546E, complete defense, they argued, if it's something that's a settlement payment made by or to benefit of a financial institution or financial participant, what Judge called covered transfers. Question is 546E's applicability to avoidance claims brought in the context of this Chapter 15, which of course brings us to 561D. Tell us about 561D.
Sure. In very basic terms, 561D extends to 546E safe harbors to proceedings brought by a foreign representative in a Chapter 15 case.
And so, Brian, then the clawback defendants argued that 561D, read in conjunction with 546E, had to mean what?
Well, the defendants argued that the plain text of 561D makes 546E applicable extraterritorially to bar the liquidators' avoidance claims, as well as their common law claims.
Okay. Now, interestingly, the BVI liquidators are also able to read English, and they see 561D says that. So they have to come up, it appears to say that, they have to come up with some plausible argument about what else 561D might possibly mean, or they're going to clearly lose. So what did they say it meant?
So they acknowledge that 546E bars certain avoidance claims brought by a Chapter 11 or a Chapter 7 trustee. But they contend that 561D does no more than make Section 546E equally applicable or inapplicable in a Chapter 15. And since 546E does not apply extraterritorially to an avoidance action by a Chapter 7 or a Chapter 11 trustee, it does not apply to an action brought by a foreign representative.
So they're saying it's just going to be the same in 15, but if the same means it doesn't apply extraterritorially, then it falls off the table. Okay, so it seems like very important threshold issue is, does 546E apply extraterritorially? Now, curiously, very interestingly in the opinion, Judge Bernstein says, quote, asking whether Section 546E applies extraterritorially is the wrong question. So what is the right question that sort of leads to that?
The right question is whether 561D makes the safe harbor applicable to proceedings brought by a foreign representative in a Chapter 15 case seeking to avoid purely foreign transfers under foreign insolvency laws.
And so that's what he said. And so what did Judge Bernstein hold, and why did he hold that?
Well, he says the plain text indicates it does, and his reasoning was 561D serves two purposes. First, it prevents a foreign representative or a U.S. bankruptcy court from interfering with the enforcement by a non-debtor of its closeout rights. Okay. And second, 561D limits the foreign representative's ability to recover property transferred in connection with the earlier exercise of closeout rights.
So what are the implications of that holding? I mean, having said this, where are we now? If 546E can be applied because 561D to block actions brought from BVI cases involving foreign funds, where are we?
Well, I mean, obviously, it's going to limit, in this case, the liquidator's recovery or potential recovery to the extent the 546 safe harbors do apply to the specific facts of this case.
So, quick question, we're about out of time. Is there any need for harmony? A currently pending question in the Second Circuit is the extraterritorial application of the avoiding powers themselves in the clawback provision 550. Do those have to mirror or not?
Well, obviously, if they did mirror, everything would be logical.
Yes.
But I think given the well-stated policies behind the safe harbor provisions, you can argue that we can exist in a world where the U.S. Bankruptcy Court gives extraterritorial effect to those safe harbor provisions, even if the Bankruptcy Code's avoidance and recovery provisions do not themselves apply extraterritorially. And I think you get to the same result on some of these.
We will see what happens, both with regard to the extraterritorial decision through the Second Circuit on the clawback actions themselves, but also with regard to the defense. Judge Kaplan, Brian, that's all the time we have today. I want to thank you again for a lively hour, and we thank our audience for watching. There's an archive of past episodes on our website under Eye on Bankruptcy. Next show, which will air March 28th, same time, and joining me will be my guest, Judge Keith Phillips from the Eastern District of Virginia, and Eric from Perkins Coie in Chicago. Until then, this is Charles Tabb reminding you to elevate your understanding and keep your eye on bankruptcy. Thank you both very much.
Thank you.